0. We were waiting on audit. Where are we?
Judge, I'm happy to announce, thank you for the court being so lenient with us and resending this a few times. Mr. Wimberly is actually here this morning with his client, my complainant. They did send me some documentation just right before docket. He's also indicated that his office is this week making notebooks for Mr. Kelly and myself and having everything scanned in. If we may just have one final, now that we have all that information, hopefully we can I can sit down with them, then Mr. Kelly and I can sit down and discuss it and see where we are. We'll be ready to finally announce next time, but I did want to confirm we do have all that documentation ordered.
Okay.
It should be to me this week.
All right. Thank you, Mr. Wimberly. All right, so what I'm going to do,
And if you want to go ahead and put it on the trial docket, Judge.
no.
I certainly would understand.
Yeah, no, I just want to, let's see.
My only concern when I hear notebook is.
That's what I'm
I don't
thinking
know
as
what
well.
we're talking about.
Yes, sir.
It'll be about that thick.
Okay.
It would all be heavy.
So why don't we do this? When we come back next time, I want it all done and I want an answer. And so what I'm going to do is reset it to the 1st of January. That should be about a 60-day, a little more than that. I want everything hopefully turned over this week. That gives you an opportunity. So unless there's something else that comes up, I want it all gone through in an announcement at the next court date.
Yes, ma'am.
Okay? All right, you're free to go. Thank you, sir.
Thank you.
Thank you, Mr. Kelly. All right, ma'am, you're Brianna Clayton. And will your client waive the formal reading of the indictment?
She will.
Ms. Clayton, in cause number 25, DCCR 0446, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from March 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kittler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine.
I'll explain my scribbles, Your Honor.
Oh, that's CCCR. There would be
Yes,
a
there's
dismissal
misinterpretation.
in cause number 25 CCCR 1119, and this will run concurrently with 25 CCCR
1053.
1053. Is that your understanding?
There should be another misdemeanor. It was refused. I was refused.
And what are those
The
cases?
dismissed one is resisting arrest, and they're all connected to this, Your Honor. The dismissal is a resisting arrest. The case to be pled is a DWI.
Okay.
All out of the same criminal episode.
Let me look at something real quick. Oh goodness, I can't see that. If I test you this morning, will you be clean?
Be honest.
Have a seat in the jury box. Good morning, are you Ryan Hodge?
Yes, ma'am.
And Mr. Hodge is charged in cause number 24, DCCR 1167.
He's saying,
With the third-degree felony offense of evading arrest or detention with the use of a vehicle. The indictment alleges a prior burglary from 2015, and then also felony of bribing an officer in 2018 and possession of a firearm by a felon in 2018. We had reset that as well, some other stuff as well.
those are out of state.
Yep. So what that means, though, is for punishment purposes, if Mr. Hodge, if you're found guilty by a jury, you would be considered a habitual offender, which means your minimum punishment, if you go to trial and are found guilty, is 25 years in prison, up to 99 years or life in prison. Do you understand? And we reset this case for you guys to watch the video, and have you had an opportunity to review the video in this case?
I've seen the prior, like, version,
You seen the video?
I think
Yeah,
he's
I've
seen
seen
it with his
Okay,
previous.
so you've
attorney.
seen the video, and have you talked to Mr. Kimmler about it? Answer out loud.
Do I know?
Have you
We've talked about the video.
Yeah, we've talked about it, yes, ma'am.
Okay, and I want to make sure, so I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count one only, which is just the offense of evading arrest or detention, not those prior offenses, for a cap of 10 years, which means you would leave your punishment up to me. I can give you 10 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that?
Yes, ma'am.
And so I'm also making the notation here on that plea bargain rejection that I've admonished you as to what the minimum will be if you're found guilty, which is 25 years in prison. You understand? And you want to reject that and have your case set for trial.
Yes, ma'am. I didn't run it, I was just speeding, driving.
He's maintained his innocence.
All right, then I do want to make sure you understand that after today, I will not accept a plea agreement. I'll get your case set on the trial docket. There won't be a plea. We'll let a jury decide, okay?
So, for any reason, we can't look into it further, the facts and the evidence that I.
Well, that's what a jury's for. And so your attorney has discussed the case with the assistant district attorney. Their position is that it's an evading and they think they can prove that, and that's what we're going to go to trial, okay? That's what a jury's for. All right, okay, and she'll waive the formal reading of the indictment in each.
Yeah, sure.
So, Ms. Randall, in clause number 25, DCCR 0246, you're charged with a state jail felony offense of theft of property with previous convictions. And that one's from November 21st of 2024. The indictment alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985, both misdemeanors, which would get us to the state jail felony level. It further alleges that you were convicted of a non-state jail felony offense of theft April 10th of 1989, and then again November 12th of 1991, and then after that was final, October 10th of 1994. And how do you plead to that charge? And are those prior offenses true? Or prior convictions true, excuse me. Are you entering your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? All right, give me just a second to get this pulled up so I can make that notation. I think that was 1 through 5.
Five or six, depending on how we want to look at it.
Find sufficient evidence to find you guilty in each of your cases. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information on you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Vasquez, and he will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you, Judge.
Yes, sir. Good morning, you're Shay Morgan? Yes, ma'am. And Ms. Morgan, in cause number 24, DCCR 2102, is charged with theft of property. And what is the announcement?
Judge, we're going to ask for a regular resetting. Ms. Malvino and I are discussing a potential resolution. I've also been given some documents from my client that I think will help inform that process, and so.
Any issues?
No, Judge, it looks like we do, at least for purposes of this announcement, have a restitution figure, so we would need time to develop that.
Okay.
We can just share that information with the council.
Okay. And the case looks old, but I realize that you were just hired at the end of July, so we'll just do a normal reset. And then, Ms. Morgan, make sure you stay in touch with Mr. Gert so you guys can go over everything. We'll try to get an announcement at the next court date. All right, you're free to go. Thank you.
Have a good week.
Thank you. You too.
This may sound like routine scheduling talk, but this is actually a huge behind-the-scenes moment in criminal court. When attorneys start talking about notebooks, scan evidence, and audits, that usually means discovery is finally being organized. Translation? Everyone's trying to avoid getting blindsided later. Judges hate surprises close to trial, and you can hear this court basically saying, "Next time, I want answers, not excuses." This is one of those plea deals that sounds better than it actually is. Deferred probation can be a lifeline because if completed successfully, it may avoid a final felony conviction. But the flip side? It's a legal tightrope. One violation, missing meetings, failing a test, catching a new charge, and the judge can bring the entire case crashing back down. Freedom with conditions is still pressure. And there it is, the number that changes the entire atmosphere in the courtroom, 25 years minimum. That's because prior felony convictions can dramatically enhance sentencing exposure under habitual offender laws. So when the judge carefully explains the plea offer on the record, she's protecting the case from future appeals claiming the defendant didn't understand the risk. This is one of the most high-stakes choices a defendant can make, gamble on trial, or accept certainty. Phew. That line hits hard. Once a judge closes the plea window, the case shifts into full trial mode. And psychologically, that changes everything. Prosecutors prepare differently. Defense attorneys prepare differently. Even defendants start realizing this isn't negotiation anymore, it's combat. And notice the judge's tone here, calm, direct, almost clinical. Because in court, life-changing decisions are often delivered in the most matter-of-fact way imaginable.